So good morning. I am Jill Perrin. I am MetroIBA's admin, and I'm excited to welcome you this morning to our education webinar series. Today we are honored to have Jason Raether of Hellmuth Johnson for wage and hour issues for Minnesota small businesses. We are going to record this webinar, so we will be able to provide you with those links after. And if you miss something or you want to go back to it, we will also provide presentation slides later. So you should be able to get all of the information from us. If you would like to have questions or anything, text those into the chat box and we will get those to Jason. If there's time, we may do Q&A at the end as well. So make sure you get your questions in. We're happy to have you on board this morning. So with that, I will give you Jason. And again, thank you for joining us.
Good morning, everyone. My name is Jason Raether. As Jill said, I'm an attorney at Hellmuth Johnson. I practice primarily in the employment law side, although I do some other matters. I handle both plaintiff and defendant employment work, so I'm familiar with these issues both from the side of the person bringing the lawsuit and defending against it. Some people have employment practices insurance. If a business can afford it, it's usually a good idea, but on the other hand, sometimes people can't afford that insurance, and then they need to call me when they get sued. Conversely, employees will oftentimes call me about employment questions related to their work. This presentation is designed to cover a multitude of issues that affect Minnesota small businesses. And so there's two important components to what I just said. First of all, there's a lot of issues. I'm not going to have time to get into a lot of the nitty-gritty details of each one of those. However, what I hopefully will be doing is flagging for you issues that can arise when operating your business so you can anticipate these issues, and if you feel that you have further questions or any other competent employment attorney in Minnesota should be able to provide information on these. Second, I want to emphasize that this is a Minnesota-focused presentation, so I'm not going to be talking about the law in other states. I'm not going to be talking much about federal law, except to the extent that it applies in the overtime realm. So I just want those two important caveats. I will be moving on. But first of all, I want to just make sure, can people see the slide that's up right now? It says wage and hour issues for Minnesota small businesses. Can somebody just text to say if they see that? Excellent. Okay. Thank you. I will be moving on. So again, these are the topics we're going to cover. It's a lot of topics. Minimum wage issues, tips, overtime, prevailing wages, deductions, and by deductions what I mean is what can you and what can you not deduct from an employee's paycheck. There's mandatory postings and records that you are required to keep. I'm going to talk briefly about how wage laws are enforced, and then I'm going to go into what are the best practices for a Minnesota small business to avoid facing a wage violation. And then, as Jill said, if we have some time, we can field some questions. So first of all, minimum wages. Minimum wages are determined by the Minnesota Fair Labor Standards Act. This slide is a little bit old. They were amended in 2014. There were incremental increases with the last one in August 2016. I'll get to those amounts in a moment. And then starting in 2018, the minimum wage will be indexed by inflation. Now, there is a multitude of governmental entities that can come in and set their own minimum wages. The federal government sets a minimum wage. Minnesota's minimum wage is higher than the federal government's, and so in this case, you'd use the Minnesota minimum wage. There's also municipalities that are attempting to set their own minimum wages, and again, if the municipality's minimum wage is higher than the state or federal, then you would go with the municipality's minimum wage. There's also different categories or tiers that apply that is based both on the type of the employer and the type of the employee. So it's a little bit confusing, but you go with the jurisdiction that has the highest minimum wage, but then when you're looking at the different categories or tiers, you can choose the lower wage tier, and hopefully that will make sense as we go into these. One more point before I move on. Minimum wages apply to employees, not independent contractors. Contractors are paid based on a contract price. The determination between whether somebody is an employee or an independent contractor could be an hour-long presentation in and of itself. It's a very complex determination involving numerous factors. Many times I have clients who have classified employees incorrectly as independent contractors for tax purposes or to avoid the possibility of paying health insurance or other issues. it's really it's a very dangerous maneuver. It can carry not only wage penalties, it can also carry consequences from the IRS and tax consequences. So I just want you to be aware that if you are considering whether somebody's an employee or an independent contractor, it may be worth talking to an attorney. We do single one-time consults on issues like that if that's something you wanted to talk about. But misclassifying somebody as an independent contractor just because it's easier is not advised. So without any further ado, the categories of wages. As I said, minimum wages are split between several different categories. First of all, there's the large employer and small employer category. It's important to note that these are annual gross dollar values. It's not the profit that the business makes. That's the amount of money that it brings in gross. At $500,000 or more, you would be categorized as a large employer. With less than $500,000, you are a small employer. Further, there's a training wage that applies, and that applies to employees that are younger than 20 years and only in the first 90 consecutive days of their employment. So that's one of the categories. There's also a youth rate that applies to employees younger than 18 years. And then there's a J1 visa rate. The J1 visas are used for employees of hotels, motels, etc. They work underneath usually a travel exchange, visitor, non-immigrant visa. A lot of words have more or less say that it's a temporary visa that allows them to work for a limited period of time. So as of August 1st, 2016, the minimum wages for large employers, they're on there on the screen, $9.50 per hour for large, $7.75 for small employers. Training rate is $7.75 per hour. Now, as I said, among the classifications of wages, you can pick the smaller rate. So if you are a large employer, you can use the training wage, even though large employers usually are at $9.50 per hour. Same thing with youth rates and J1 visa rates. As you see, if you're a small employer, it's $7.75 per hour, regardless of which classification you're in. But again, if you're a large employer, there's different classifications for youth and J1 visas and for training rates. These are higher than the federal minimum wages, so these will take place over the federal wages if you are operating a business in Minnesota. Now, it's important to note that, as I said, that the minimum wages will be going up. They will be indexed to inflation. That's based on the implicit price deflator. If you wanted that explained, you'd have to ask somebody else. I don't entirely understand how the U.S. Department of Commerce determines inflation, but it is a number that you can get from the Department of Commerce, and the increase is capped at 2.5%. We've been at very minimal inflation since the turnaround of the economy. I guess you could say it in session. A lot of people think the recession ended around 2014. There's a lot of debate on that. Regardless, inflation has been low, but at any point we could see much greater inflation, at which point the minimum wages will be going up along with that. Again, capped at 2.5. Now, the Department of Labor and Industry, that's the Minnesota agency that regulates wage issues, it can suspend annual minimum wage increases. This is the first time that Minnesota will be doing this, and so we will see how this process proceeds, and we'll find out in 2018 whether minimum wages will be increasing based on any inflation. And then there's some local rules on wages, and as I said, local municipalities can enact their own wages. There's some debate about that. The Minneapolis City Council, for example, mandated sick leave for employers in May 27, 2016. That's to go into effect in July of 2017. That applies to employers with 6 or more employees. Those of you who have been following the news may have noted that the Chamber of Commerce brought a lawsuit to enjoin, which is a fancy legal word to say stop, the implementation of this change. In January, Judge Mildickstein ruled against that injunction to an extent. Here's the way it's going to work. Minneapolis businesses, in other words, businesses with their principal place of businesses located in Minneapolis, will be affected by the sick leave ordinance. Again, that applies to 6 employees or more. It applies to employees who can earn up to 48 hours per year, and there's a rate of 1 hour per lead per 30 hours worked. The Minneapolis City webpage should have all the information on that if you need those details. Private employees working at least 80 hours in a year will be entitled to benefits. This only applies, again, to businesses that are located in the Minneapolis area. If you are an outside business who does business occasionally in the Minneapolis area, Judge Dickstein's ruling, in essence, says that it does not apply to you. So if you deliver product to Minneapolis, or maybe you have a branch in Minneapolis, that's a little bit more of a hazy situation. But it's your principal place of business, your residency of your business, that will determine whether minimum wage applies. And let me restate that, whether the sick leave applies. Those of you who follow the news may also recall that Minneapolis attempted to raise its minimum wage to $15 per hour. That measure ended after a study was released. There was a lawsuit about whether that could be made a ballot measure or not. And Judge Robner ruled that that is not an issue for the ballot, for the voters to decide. This ended up going up to the Supreme Court, and the Supreme Court decided or ruled that voters cannot decide to reset the minimum wage in Minneapolis what they wanted to. Instead, that needs to be a city council decision, and the city council has not elected to raise the minimum wage at this time. That's a lot of information for something that didn't happen, but at any time we could see a change in the future if the city council goes forward, although it's now a settled issue in Minnesota that you cannot do a minimum wage raise with a ballot initiative. The MSP Airport Board approved minimum wages back in May 11, 2015. Their minimum wages went up to $10 per hour. So if you're a business that has a location at the MSP, there's actually a higher minimum wage. So it's not entirely clear whether the municipality even has the authority to impose its own minimum wage under state law. The Supreme Court somewhat punted on this issue when reviewing the Minneapolis ordinance. And I would expect, as municipalities continue to try to enact their own minimum wages, as cities like Seattle and San Francisco has done, there's going to be continued court challenges. The decisions in those states would be restricted to those states, but I would expect to see another effort at some point by the city council in either Minneapolis or St. Paul to raise the minimum wage, and we may actually see that issue play out, whether the municipality has the authority underneath the state constitution to make its own minimum wage. There was a legislative law that was presented in the 2016 session called the One State, One Rule Law. Didn't make it through the legislative session. My money would be that Dayton would not sign a rule like that, so I would not expect that during his term. But I know that there's some legislative efforts to standardize minimum wages across the board in the state. As far as what happens in politics, everything is obviously uncertain. Maybe there's some sort of compromise or deal that would be made between the House and the Senate and the governor to pass a law that would probably involve another raise to the minimum wage. But as it stands right now, there's no rule that prevents local governments and municipalities from enacting their own minimum wages. I apologize for the small font on this slide, so hopefully you can read what's here. This is important. These are the employees that are exempt from minimum wage laws. Younger agricultural employees, in other words, the daughter or the son who works on dad's farm does not need to be paid minimum wage. Salespersons who conduct no more than 20% of their sales on the premises. In other words, this will be your traveling salespeople. Volunteers for nonprofit organizations. I know I put in be careful when it comes to internships. There is actually a number of law firms in New York, and of all places, the law firms just assumed they could not pay minimum wage because it was an internship, and the New York equivalent of the Department of Labor and Industry came down on those law firms pretty hard. It's got to be a nonprofit organization, which means registered with IRS as nonprofit before you can not pay your volunteers. Taxi drivers and babysitters are exempt. And then individuals employed on a seasonal basis. Now I want to make sure that there's an important caveat there. Individuals employed on a seasonal basis, the minimum wage applies, but overtime wages do not. Maybe this should be on another slide. But in other words, if people running the Tilt-A-Whirl, you still have to pay the minimum wage, but you do not have to pay them overtime wages. So, all right, moving on. Minnesota is unique. Unique is not the right word, but it's one of only a handful of states in the country that do not allow a set-off to the minimum wage for tips. In other words, in a lot of states, if you make $50 in tips in a night, that counts towards your wages for the purposes of determining minimum wage. Minnesota does not do that. Minnesota requires that everybody is paid minimum wage regardless of how much they make in tips. The server at Meritage, who makes $200-300 a night maybe on tips, still has to be paid their minimum wage. And that was one of the reasons that the Minneapolis effort to raise the minimum wage failed. That was met by a lot of resistance by the restaurant industry that's required to still pay minimum wage regardless of tips. Now, you can have tip sharing between direct service employees, but that does not include bussers, cooks, dishwashers, or server assistants. Now that's mandated tip sharing by the employer. Employees can decide to share tips with non-direct service employees, for example, tipping out the busboys or tipping out the cooks, but the employer should do nothing more than facilitate a pre-existing agreement between employees. There's a case where Starbucks had a tip jar for baristas, and what would happen is Starbucks would wait until the end. This is one of the Starbucks locations, not a corporate decision. It would wait until the end of the day. They would throw all the tip jars into one big pool and then divide it by the hours worked. The employees who worked specific shifts brought a lawsuit and succeeded, saying that those tips that they earned during their shift were theirs. And I'm not going to get into the merits of that decision, but regardless, it's important to keep in mind that if you have tip sharing, it should only be between direct service. In other words, the person who comes to the table and takes the order. And otherwise, if the employers and the employees want to do it, that's fine, but the employer should not have any sort of definitive say in how that is run. I'm going to move on to overtime now. It's a big issue, and yes, I will get into the changes that are possibly coming down. So first of all, same thing as with the large employers underneath minimum wages, overtime rules apply to businesses making $500,000 gross in annual sales. And I should state that these are federal rules. These are not Minnesota state rules. Further, the employees must receive overtime pay for hours worked over 40 hours in a work week. It cannot be less than 1.5 times the regular rate. A lot of employers will decide to pay somebody what they call a salary and assume that this means that they no longer need to track their hours. That is not the case. Whether somebody is eligible for overtime or not is not determined by the form of their payment, nor is it determined by their title. You can't call somebody a manager and just assume that you don't have to then pay them overtime. You have to fall within several exemptions. I'm going to go through a couple of those. There's two main broad categories of exemptions, and then I'm going to go into the details. There's the white-collar exemption, and that's the salary of $455 per week or $23,660 per year. And that's not and that salary is not subject to a reduction based on quality or quantity of work. So it's important to remember that if, for example, somebody's paid commissions or somebody gets more money or less money based on whether they perform, you look at the base pay for the white-collar exemption. And I'm going to go into the actual duties that you need to fall underneath the white-collar exemption. It's not just enough to pay them that much money. You need to further fall within what's called the standard duties test. The other broad category is highly compensated employees. Those are people who are making $100,000 or more annually. The threshold to show exempt status is much lower. I have a hard time thinking of many situations where somebody would be violating overtime laws if they're paying somebody $100,000 or more annually. The duties test is very relaxed at that point. So this is, again, the standard duties test. These are the $23,660 or more a year. You have the executive exemption, the administrative exemption, the professional exemption, which is broken into two categories, the computer employee exemption, and then the outside sales exemption. I'm going to spend more time on the first three, and I'm just going to briefly touch on the last two. Now, the executive exemption, this is the usual case where people think of somebody being a manager. They need to be managing a business or in a recognized department or subdivision. They need to have the ability to direct the work of at least 2 or more other full-time employees or their equivalents. I've had clients who run restaurants that have a head chef. Turns out the head chef doesn't have anybody that works underneath them. That person would not be exempt from overtime requirements, at least underneath the executive exemption. So you need to have that component. And then they must either have the authority to hire or fire, but there's a much looser version of that. As long as their suggestions are given particular weight, that would be sufficient. So, for example, if you had a manager that you're hoping to classify underneath this exemption, ideally any hiring or firing decisions made in people in their department would document this person's suggestion as to whether they should be hired or fired, and that would go a long way to support whether this exemption applies. Now, the administrative exemption, these are your office workers. It must be the performance of office or non-manual work, must be related to the management or general business operations of the employer or the employer's customers. And this is the important part. They need to be able to exercise discretion and independent judgment on significant matters. In other words, the receptionist is not going to fall underneath this exemption. There needs to, and this is obviously a broad and flexible category, but they need to be given a lot of control on how they exercise their job duties. If they're given a very strict list of job duties and instructions on how to perform them, most likely the administrative exemption will not apply. The learned professional, these are your doctors, your lawyers. It must require advanced knowledge. The work is predominantly intellectual in character. I will leave it up to you whether law falls in that category. And then it requires a consistent exercise of discretion and judgment. It must be in a field of science or learning, and that there usually needs to be a prolonged course of specialized intellectual instruction. In other words, you probably should have some fancy letters after your signature if you are going to fall within the learned professional exemption. There's also the creative professional, and this is a much harder to define category. This is a performance of work that requires invention, imagination, originality, or talent. These are your artists. I mentioned the head chef before. If you had a chef who's renowned, who's opened up numerous restaurants, whose recipes are written about in food magazines, you possibly could have a chef that would fall within this creative professional exemption. The person that you hire to paint your office walls will not fall in this exemption, even if they get to pick the color. So you need to focus on how much is it involving an artistic or creative endeavor. In cases of doubt, it's better to assume that somebody does not fall within the exemption. Again, if you want to speak to an attorney, you're welcome to contact me. We can set up a consult to go over a specific case like this and try to help you determine whether the exemption applies. Before I move on to recent developments, I'm going to go back up to the other 2 categories and just talk about them briefly. Computer employee exemption. This does not mean IT staff. This does not mean help desk, at least according to a 6th Circuit ruling that recently came down. Computer employees are people who need to program computers, design computers. There needs to be a component of the job where they are creating something new with technology. If all they are doing is working with an existing set of specifications to fix a problem, that would not qualify. In the 6th Circuit case that I mentioned, the employers argued that they had their IT staff install hardware. And in essence, you're building a new computer because you're installing hardware components on a motherboard. The 6th Circuit disagreed, and I believe that a lot of other circuits would as well, holding that you're still dealing with the preset specifications of what components fit with what components. Now, if you had your IT staff designing CPUs from the ground up, they're probably not qualified they're probably overqualified as IT staff, but that's the type of thing that you need for the computer employee exemption. Now, they created this exemption specifically distinct from the learned professional because they recognize that there are people who have as high degree of knowledge and qualifications as the learned professional who may not have had any formal education past high school. So there's no specific education requirement for the computer employee exemption. Outside sales exemption is what it implies. These are your traveling salespeople who do not perform a majority of their work within the office. And again, if you want to go into any more detail, please feel free to give me a contact me or let me know if you have any questions afterwards. Okay. As many of you, I'm sure, have heard, the Obama administration increased that threshold for the exemption, and this is the standard exemption, to double. And I hope I'm not giving anybody a whiplash here. I'm going back up to the white-collar exemption. So it's salary there, $455 per week, and then $23,660 per year. Underneath the Obama administration's ruling, underneath the Department of Labor, those numbers were doubled. So you're looking at about 47 something per year and a little bit over 900 per week. In other words, if you weren't paying somebody at least that much, you would not be able to take advantage of any of those exemptions that I've gone through, the executive, professional, computer exemptions. In other words, a lot of employees who were previously classified as, let's say, a classic case would be a general manager. I keep using restaurants as an example. A general manager of a restaurant frequently may not be paid $47,000 a year. However, they would certainly fall underneath the executive exemption test. So this rule change had the possibility of affecting a lot of smaller businesses who had people who would normally be from overtime that suddenly would have to be paid a lot more or be paid overtime. So a number of parties brought a lawsuit. They don't pick these venues by random. They brought this lawsuit in the Eastern District of Texas, and the federal judge there issued a preliminary injunction against the administration's rule. It's important to keep in mind that a preliminary injunction is not a final decision, but as part of deciding to issue an injunction, a judge needs to decide, I think they're going to win. That's in essence what a judge is doing when they're issuing an injunction. So this is a good indicator of the result. In the meantime, the judge says, I think they're going to win, and so you cannot continue doing what you are going to do until this matter resolves. In other words, the new overtime rule is currently in abeyance, or it's on hold. Now, the Obama administration appealed this ruling, but as you may have heard, President Trump was elected as president and became president January 20th, 2017. It's not clear whether the Trump administration will continue the appeal of this ruling. The briefs were originally due on March 2nd, 2017, and the Department of Labor requested an extension to June 30th, 2017. My personal take on this is that they're deciding how hard they want to fight this, whether this is something they want to continue to fight. I would not be surprised if on June 30th, 2017, the Department of Labor issues brief saying we do not appeal Judge Mezant's ruling, which would mean that the preliminary injunction would stay in effect. In essence, this would end the change that I previously discussed. So we're in a little bit of a period of flux. Right now, the old rules are still in effect. There's some possible outcomes here. The Department of Labor could issue another rule, but the Administrative Procedures Act requires that there's a notice and comment period. When a government administration issues a rule, it's a long period. They need to publish it. They need to get comments. They need to consider the comments. They conduct hearings. In other words, it is not an expeditious way to change the rule. Another one is an executive action by President Trump. It's a little bit unclear of whether that would be constitutional, and I'm sure we would see some lawsuits if he did that, but it's certainly a possibility that he could just sign an executive order stopping the enforcement of the administrative rule. He could also instruct the Department of Labor to just ignore the rule. We've seen this in previous presidents who, even though there's rules and laws, they can give enforcement priorities to their agencies, as President Trump has already done. Again, if he were to do this, I would expect there to be some lawsuits. There's also the Congressional Review Act, and you see that struck out. The Congress did not. They had I believe it was until last week or the week before. Apologize, the deadline is not in the forefront of my mind. To have Congress review administrative acts and then strike them down. It's a rather powerful tool. They did not use it in the case of this rule, so it's either going to be decided in an appeal or administrative action, or possibly by an executive action. I get a lot of questions about whether it's going to apply retroactively. And unfortunately, I cannot say for certain whether it will or not. It really will come down to the judge. There's a lot of opinions about this. My personal, I believe that it is unlikely that the rule will be applied retroactively. I don't think that a judge would expect businesses during the issuance of an injunction to somehow abide by a rule that's not even in effect. I would expect that if it is suddenly applied, that would be applied with maybe a window for implementation. But we're still in a very hazy area here. It's difficult to tell what's going to happen with the overtime rule. So keep in touch with, keep your eyes on the news. I also post blogs on my website occasionally about changes to the overtime laws. You're welcome to check that out, or just feel free to contact me if you have any questions, and I can let you know where we are. So here are the requirements that come with overtime. You must have a system in place to track the hours, and you must track the employee's wages on a quarterly basis. A calculation of overtime, I'm not going to get into all the nuances as to how you calculate their hours, and I'd be happy to talk about that in some detail. What's important, though, is that you're tracking their hours. You may recall that I said just because you call somebody a salaried employee does not mean they're exempt from overtime. Well, if it turns out that they don't fall within one of the exemptions that I discussed, and the employer has not tracked the hours, that's a major enforcement issue for the Department of Labor. So if there's any question about whether somebody is actually going to fall underneath an exemption, the employer should be tracking their hours and also tracking what they're paid on a quarterly basis. It's determining whether they fall within the exemption is actually done on a rolling quarterly basis. And again, I'm happy to discuss some of the nuances of that offline if anybody wants to go into how that is calculated. I'm going to talk briefly about prevailing wages. This will not apply to many of you, potentially not to any of you, so I don't want to spend a lot of time on this. But in essence, what this is it requires that contractors pay wages similar to other wages paid in a community for projects involving state or federal funding. And you notice I called out projects there. It's a highly defined term. So a lot of times these cases come up around road work. So the project will likely be, if asphalt and concrete are being mixed on site, that's the project. If there's work being done to create the materials off site, that may not fall within the project. So there's a lot of details as to how this works. This will cover your laborers, your power equipment operators, truck drivers, special equipment, special crafts. The amount of the prevailing wages is set by DOL, Department of Labor and Industry, and it's defined by the category of work. You just heard me go through several of those. It's further split between base and fringe amounts. In other words, base is the dollar amount that they receive, and then an employer is allowed to add in a certain amount of that as fringe benefits. And importantly, it applies to all employees of subcontractors. And general contractors will be liable if the subcontractor does not pay the prevailing wage. And so if you are a general contractor who works on state projects, you will probably want subcontractors that either have worked on state projects before and understand prevailing wage, or you're going to at least have to do some work ahead of time to make sure that they are up to speed, because if not, the general contractor can be held liable. I also give subcontractors the same advice. If you're working with a general contractor on a state project, you may want to determine whether they have worked on state projects before, whether they are up to date on federal and state prevailing wages, because if a general contractor has a wage enforcement clause against them, that can obviously have trickle-down effects to everybody working for the general contractor. In essence, I just recommend consulting an attorney. If this is your first time working on a state or federal project, there's a lot of nuances to prevailing wage that I'm not going to go into now that you will want to be aware of before you start the project. Next category, deductions. As I brought it up before, I'll bring it up again. You cannot deduct from wages based on the tips that the employee received. Second, you can do some deductions, but not if they bring the employee below the minimum wage. You can deduct for purchase or rented uniforms. You can deduct for purchase or rented equipment. However, this does not apply to tools of the trade. In other words, you could not deduct from, let's say you had again, I use the restaurant exception. You could not deduct from a chef's pay the cost of their pots and pans. If you had an employee who works at a hair salon, a lot of these are independent contractors, some of them are employees, you couldn't deduct the cost of their scissors and hair cutting tools from their wages. Consumable supplies required in the course of employment may be deducted, and travel expenses may be deducted if you are paying out the travel expenses. You cannot make those deductions if they bring an employee below the minimum wage. A lot of times I just recommend employers not to make these deductions. I mean, that's going to have to be a decision made from employer to employer, but there's a lot of traps there for the unwary if you begin making deductions for some of these items. So, for example, I was asked in one seminar, well, what if an employee wants to buy 7 uniforms? Can I then deduct below minimum wage? And I mean, at that point, we're kind of getting into the realm of hypotheticals. I mean, in the case of uniforms, is what are they required to have for work? 1 or 2 uniforms, maybe. Again, if you don't make the deduction, it's not something you have to worry about. Now, there's cases where you can't make any deductions regardless of whether it affects their wage rate. This includes damage, loss or stolen property, or indebtedness. In other words, you may think that your employee is stealing from the till. The way to deal with this is not by deducting from their wages. If an employer does that, they're committing a wage violation. I know that seems probably grossly unfair. The result or the alternative there is to actually, if it is a large enough amount, to sue the employee. There was a case recently where a valet company sued actually had reduced wages because of multiple damage that the valet had done to cars, had done about $8,000 worth of damage to vehicles. So really a terrible driver, should not have been working as a valet. And the employer deducted the wages based on the damage that valet had done to the cars. And the court ruled that that was an improper deduction. Again, it needs to be, if you want to get that money back, you need to sue the employee. The other alternative is if the employee provides written authorizations. So a lot of times what I have with small businesses, I have employees that borrow money from employers. And I generally do not recommend that employers lend money to their employees, but if they decide that's what they want to do, or if they decide that this particular employee is special, it is ultra important to get a written document from the employee allowing the employer to deduct from their wages for the amount of the loan. Otherwise, if it's an oral agreement, you don't have a writing, and you make a deduction, the employer is then committed a wage violation. There's several postings that you're required to have up on at your work, and these are the things you'll see in the break room. This is regarding minimum wages. There's other categories. You can find these posters on the DOLI website, and in fact, if you contact DOLI, they will print and send you a packet of posters for free. So there's no reason not to have these posters up. They need to be somewhere where employees commonly see them. This is why break rooms work particularly well. If your place of employment does not have a break room, a frequently used hallway would probably suffice. Further, employers are required to keep records of each employee. Now, these are requirements put up by the Department of Labor and Industry, but at the same time, these are also important requirements. Important records in the unfortunate event of a lawsuit. These include obvious things like name and address, occupation, rate of pay, the amount of pay, hours worked. If you have a payroll system like ADP, you can keep their payroll records in their file. Just in general, you want to keep a file for at least 3 years in or near the premises where the employee worked. So hopefully all of you are keeping employee files with this information. There's additional record requirements if the employees are performing public work. In addition, these are not requirements, but if the employee is ever written up, that should go into their file. If the employee receives performance reviews, those should go into their file. If there are wage changes, either a raise or in the unusual case of lowering of a wage, that should go into the file. Emails that the employee sends that relate to their employment, that should go into their file. You really can't keep enough documentation in an employee file. The one exception to that would obviously be communications that you may have with an attorney. You would not want to put that, obviously, in the employee file. Now, the employee handbook, I have underneath necessary records. It's not required by law, but I can't recommend having an employee handbook enough. There are so many aspects to having a good employee handbook. For example, a sexual harassment reporting policy, in my opinion, is a must-have for any business. And if you don't have an employee handbook, well, then you're just dealing with a bunch of different policies you're maybe having people sign off on. An employee handbook is a great way to put job expectations together with reporting policies and helpful information all in one place. The employee handbook ideally will have a signature page so that the employee acknowledges receiving and understanding the handbook. The employee should be given time to read and review the handbook. Passing it across their desk and giving them 5 minutes to look at it or demanding that they sign will not suffice. Ideally, they have a copy of their own to keep, and then that signed acknowledgement should go in their employee file. So, enforcement of wage laws. This is the not-so-fun part of the presentation. It's how DOL comes after your business for potential violations of wage laws. And the employee can make a complaint to the Department of Labor and Industry, and then the Department of Labor and Industry will conduct its own investigation. They have investigators that go out that will talk to the employees, that will talk to the employers. And then the commissioner then can issue a compliance order. And if there's, now usually that's discretionary, but in the unusual case that, it's a repeated violation, and there's a complex definition of what repeated is, then the commissioner must issue a compliance order. After the commissioner issues a compliance order, the employer has 15 days to file a written objection. 15 days is not a lot of time. A lot of times I get calls from clients who got a compliance order 20 days ago. And there's ways around that, but it is not ideal. If you get a compliance order, your first step should be to contact an employment law attorney and find out what your next steps are going to be. In fact, my recommendation is when DOL is doing an investigation, they may be talking to you or your managers. I like to use the phrase from the Miranda warnings, anything you say can and will be used against you. If you are talking to a DOL investigator investigating a possible wage violation, you should assume that your statements they may not be recorded, but that the investigator is keeping careful notes and that the things that you're saying can come up later if there is a lawsuit. So my recommendation is actually, and you'll see these later, as soon as you get contacted by DOL about a potential wage violation, to talk to an attorney. The commissioner may also start an action in district court, in other words, start a lawsuit to enforce its orders. Now, that's one route that an employee can enforce. A lot of times, though, what happens is an employee will bring a civil action directly. In other words, they can sue an employer directly without going through the administrative process of using the Department of Labor. And as I described in that, let's say that they did go through the administrative process and DOL said, wait, there was actually they're fine, there was no violation. The employee can still appeal that determination to court. So just because DOL says an employer is clear does not mean that the issue is resolved. And also, it should be important, this goes back to what I said about when you talk to DOL investigators, DOL communicates with other government agencies. So if during its investigation it finds out that the independent contractors that were employed at your business are actually employees, it may also contact the Minnesota Department of Revenue and let them know that there may be some additional tax issues. In other words, there could be spiraling problems, which is all the more reason to be extremely careful when you're talking to investigators from DOL regarding wage issues. So consequences. An employer may be required to pay back pay, gratuities, and compensatory damages. There can be a civil penalty of $1,000 for each violation. It's also a crime to not pay the minimum wage or to keep proper records. Those required items I went over earlier, an employer is actually committing a misdemeanor by not doing these things. Now, obviously, the business won't be convicted of a misdemeanor. It will be the individual in charge of the business. Further, if an employer hinders or delays a DOL commissioner or an investigator, that is also a misdemeanor. Again, an attorney brought into this process early on can contact DOL and schedule a meeting, a time that the meeting can occur, as opposed to having the investigator show up and an employer refusing to let them in, which can, as it states there, create some legal complications. Now, if handled by the Department of Labor, the Commissioner will usually order the employer to reimburse Dolly and the Attorney General for all litigation costs. In other words, if Dolly finds that there's a wage violation, not only will they want you to pay back the employee, but then they're going to want you to pay them for their attorney time, and there's an exception for extreme financial hardship. As the name of that exception would imply, it is difficult to invoke. If this goes to district court, let's say the employee sues the employer directly, the employer could also be made to pay the employee's attorney fees. And the financial hardship exception I just mentioned, that does not apply if the employee brings a lawsuit in district court. That's just, there's a statute that states that the employer can be held liable and be required to pay attorney fees. I discussed unlawful deductions. In other words, for loss or theft, you may be required to pay twice the amount of that deductions. And again, the Commissioner may fine an employer up to $1,000 for each failure to maintain records. So the things I went through are important. You want to make sure that you're following the wage and hour laws, because there are obviously numerous negative consequences that can come up if you do not. This is one of the most difficult things for an employer is when an employee brings what is obviously a frivolous lawsuit, either as a way to try to blackmail the employer out of money, or maybe they would rather sue you than work to get their money. And a lot of employers just want to fire this person right away. I understand it. I get it. Don't do it. Firing an employee who is bringing a wage violation complaint is considered retaliation. Again, that is additionally a misdemeanor, and it only makes the lawsuit worse. The same thing applies just as if somebody was going on workers' comp or complaining about sexual harassment. Retaliation lawsuits, from my experience as an employment law attorney, are actually more common than, or at least are more likely to make it through to a trial than a lawsuit based on sexual harassment or a lawsuit based on the underlying wage violation. This is a classic case of the cover-up being worse than the crime. So I can't urge employers enough to not retaliate or treat an employee any differently, even though they're trying to bring a frivolous lawsuit that may ruin your business. And I understand how difficult that is, but it only makes things worse. So what are the types of things that you can do to reduce your risk? As I just said, I'll repeat it, don't retaliate. Second, don't talk directly to an employee about a wage complaint. If an employee comes to you and explains that they don't think they're being paid minimum wages, the best thing to say is, we're going to investigate. You are not required statutorily to give any information to the employee in response to a request about a wage complaint. There are things that an employer is required to respond to employees' requests, but it's important that you don't talk to them about what your analysis were to show. Even if you conduct the investigation and you find that there wasn't a wage complaint, I don't recommend talking to the employee about it. I can't tell you how many employee recordings, secret recordings I've had of employers, and if the message that you're giving the employee message that you give later in court testimony, it's very problematic. And so this goes to, you may catch this as a theme, if an employee is coming to you about a wage complaint and you think that it's serious, you should talk to an attorney. Absolutely, if you're being contacted by an enforcement agency like the Department of Labor and Industry, I do not recommend talking to the agency without conferring with an attorney. Again, we do one-time consults. A lot of employment attorneys do one-time consults. It is worth the time and money to sit down at least once with an attorney, figure out what's happening, what you can and cannot say. Maintain the records, maintain an employee handbook. That will help reduce your risks. And finally, make sure you have that limited liability protection. I hope nobody out there is operating a business with employees as a sole proprietorship. There's no reason to not have limited liability protection. It's cheap. There's some bare minimum requirements that you need to do to observe corporate or company formalities. This is something that can be done on a one-time basis with a consult with an attorney. You can set up an LLC yourself. I don't recommend it, but it's better that you have something in place rather than nothing. As a sole proprietor, you and your personal assets can be held liable for any of the lawsuits brought against the business. So steps: if there is a reported violation, don't panic. A lot of employers will act rashly, retaliate, try to explain themselves to the employee, try to explain themselves to the agency. Don't do that. Talk to an attorney as soon as you can. And remember that you can fight City Hall, though you should not do so on your own. I think we have a very short amount of time for questions. I don't know if we should take any questions offline, or we have 3 minutes for questions. So if anybody has any questions, I can take those now. I don't know if I can hear any of you, so you need to chat into the chat box.
While we wait, Jason, can we pop over to the next slide?
Yeah.
And I will give you a little bit of an update of what's coming up for MetroIBA. Please feel free to chat those questions in. Jason has also graciously offered to take your questions directly after, and his information will be provided. But we really want to thank you for attending today's webinar, and we hope to see you at some of our upcoming events. We have a MORB, MetroIBA's Owners Roundtable for Excellence in Business, and that's held later today. It's for members only, and if you want to find out more information, please go to our website, events, and then we'll provide you the contact information. We're excited to have the Small Business Seminar Series with Hellmuth Johnson, and on May 25th will be Transition and Succession Planning, and I know that's an important topic for many of our members and for our listeners. You don't have to be a member to listen to our webinars, but registration for that is also online on our events page, and we'd be excited to have you there. There's a breakfast provided, and it's in the morning time, so you can attend that and get on with your day. MetroIBA has a first Tuesday networking event, and that's coming up Tuesday, June 6th, 4:30 to 6:30, and that will be at Workaround. It's near the U of M campus on University, and again, details are listed on our events page. We want to give a special thank you to our webinar series host, Venture Academy, and they have graciously offered to and are providing us a great space and in their vibrant school. And we do have a question, so we will.
So, Matthew, I see your question. The employer is deducting regularly for HSA, but funds are not being added regularly to the HSA. Apparently, there's post-funding happening. I just had a quick follow-up. When you're saying funds are not being added, do you mean that the employer is not actually adding funds to the HSA? If that's the case, okay. So, if there's a deduction that's being made for an HSA and they're not being added regularly, that is problematic. It kind of depends on when the post-funding is occurring. If the funds are not added immediately, I don't believe there'd be an initial legal issue there. But one of the questions would be, are the funds that are being put in by the employee, how long after are they available to use? Because sometimes there's an administration turnaround time. So how long after the funds are being put in are they being made available? Do you know? And this may be a question too that I could handle offline. I don't charge people for phone calls. You're more than welcome to give me a call, and if I can answer any questions over the phones, I'll do that. Okay. Matthew, that is okay. I'm seeing here that no funds have been added yet this year, and the HSA account is still hasn't been funded. Yeah, let's talk offline. I think that there may be some legal issues there. I think that is that there's some problems potentially with how the employer is handling that. This whole idea of post-funding, I would understand if it'd be 2 weeks or a month, but this is unusual. I have to tell you that this is not something that at least I've run across in my practice, but I'm happy to look into it. Let me give you my direct line, and Joe, would you mind typing that into the chat? My direct line is 952-746-2145. And feel free to give me a call. I'll be back in the office this afternoon, and we'll be around most of the rest of the week. And if you don't reach me, just make sure you leave contact information, and I'm happy to get back to you and we can discuss.
Great, and with that, we really want to thank you, Jason, for your time this morning and for putting up with our audio issues at the start. And again, thank you to all of those who attended, and we appreciate your being here. And again, Jason's number is there, and I'll also provide that with the links to the recording and with the presentation slides that will go out to everybody who registered later today. Thank you very much. Bye.
Thank you for joining us.